네, 안녕하세요.
Good morning. I am Eugene. I'm the Deputy Director, International Cooperation Center of KICJ. We're having the second day. We were supposed to start at 9 a.m., but there was a 10-minute delay. I will be moderating over session 2. We had a special session and session 1 yesterday, and we're going to have session 2 under the title of Automated Decision Making and Human Rights. We have Professor Yang Chun-soo of Yeongnam University Law School, who is going to moderate the session. Hello everyone, I am Yang Chun-soo. I'm teaching at Yeongnam University Law School. We are having the KICJ International Forum, and I will be moderating the second session. In the interest of time, we will go right into the presentations and discussion. We have with us three expert speakers. I'd like to introduce them briefly. The first presenter is Professor Shim Woo-min from Kyungin National University of Education. And then we have as the second speaker, Dr. Choi Ji-sun, Associate Research Fellow of KICJ. And the last speaker is Dr. Sung Yuri, who is also an Associate Research Fellow at KICJ. Having listened to the three presentations, we will have a discussion by the first discussant, Jang Yeogyung, who's the Executive Director of Institute for Digital Rights. And we will have Dr. Kang Tae-kyung, Research Fellow at KICJ, as the second discussant. We will go right into the first presentation. Professor Shim, you have 20 minutes. Please go ahead. Hello, I am Shim Woo-min. I am teaching at Kyungin National University of Education, and I head the Center for Legislative Studies. I'd like to talk about AI technology regulation and human rights impact assessment in Korea. Basically, regulating AI, I will talk about it later, but in Korea and also in other European nations, in terms of regulation, we're still in the discussion phase. We don't have a clear set of regulations laid out yet. And so in discussing the regulations and how to formulate them, I'd like to talk about the background, and in relation to human rights impact assessment, I would like to make my presentation. When we talk about the AI technology and legal regulations and what the relationship there is between the two, AI technology is not simply, we are not just looking at AI technology per se, but it goes beyond the technology, and digital transformation is taking place. So that is the assumption that we're making. So IoT, big data, metaverse, digital twin, these concepts are all related, and we have to think about that in formulating future AI technology regulation. And as you can see from the diagram, in the past, there was human-to-human communication, and the regulations were based on that. But after the digital transformation has taken place, technology will become the medium. In IT jurisprudence, the medium is CPND, Contents Network, Platform, and Device. And recently, we see that centered around AI. So communication is taking place through the medium of AI, and it's not just mediating communication only, but decision-making by humans could also be replaced by AI. And so that is the starting point in talking about how to regulate AI technology. So that is the background of the AI technology, and to reiterate, the AI technology is indeterminate. And so traditionally in jurisprudence, there's the talk of indeterminacy of AI that is taking place, and that is still the main theme of the discussion. In making normative judgment, we cannot find one single answer. And so indeterminacy was continued, and when the AI technology is adopted, then that indeterminacy will be amplified. Autonomous decision making and judgment made by machines will be important, and we don't know what judgments the machine will make. So this is not my own statement. We also have Jack Balkin, who talked about the indeterminacy inherent in AI technology, and I quoted him. He said this in 2015. And indeterminacy of AI, why do we want to take legal response to the development of AI technology? It's very difficult to predict, but must be addressed. This is the risk that we are thinking of. And one other thing we have to consider is the society is changing to a more fluid structure, and we need to take effective response to that. So these are the three conditions that we need to take into consideration. So by fluid society, I will just briefly mention it. In the past legal paradigm, it was taken for granted that change will take place. Nonet and Selznick talked about responsive law and its paradigm back in 1978. Legal evolution theory has been discussed by other scholars, including Nonet and Selznick. But when indeterminacy is amplified and we need to address the potential risks, I think Nonet and Selznick's theory is most relevant, and that's why I am mentioning it here. And anyone who majored in this field in the period after the 1970s and 80s, the legal evolution has been taking place, and AI technology and digital transformation will be further promoting this legal evolution. So I think we have to think about AI technology regulation in response to this, how we need to accommodate the responsiveness risks or requests. And now I'd like to talk about the potential regulatory models. I'll be very brief because I'm sure you're familiar with these regulatory models. First, I need to talk about this classification, which is based on common sense, and this is not my own research. I have taken the regulatory models from an expert in this field. And the first model is the hard law regulatory model, which is traditional. It's to regulate based on the laws enacted by the legislative branch. And it's very difficult to deal with the fast-changing society and technology. And we can think of the international cooperation regulatory model. And the Roman law is in this vein. We think of the international cooperation as a given, and in the case of the internet, it is globally connected, so ICRM could be a potential answer, but it's very difficult to have the restriction on outside the state's discretion and sovereignty. if the regulation had been within the sovereign borders, it would have been easier, but sometimes that is not as clear cut. And the third model is self-regulation or soft law regulatory model. For a long time, we have had self-regulation, and so I'm sure you're familiar with this model. But basically, what self-regulation means is it does not take priority, but it follows the principle of subsidiarity. And the biggest disadvantage is it could not be as binding. And in establishing the rules for this regulatory model, the insiders and outsiders could be discriminated against and they will not be treated equally. And the fourth regulatory model is the architectural regulation regulatory model. Simply put, as I wrote down here, Joel Reidenberg's Les Informatica or Lawrence Lessig's code is the basic concept. So the technological structure made by man could be used as a regulation. So that can act like the law. And code includes the programming language, but also the code also means the law. And so that is the thinking behind the architectural regulation regulatory model. But to mention its limitations, the authority, so there is a possibility that regulations may be set outside the limits of the competent authority, and sometimes it has a black box type of property, so it cannot always be democratic and transparent. So we looked at these regulatory models in the AI or digital technology, soft law, and architectural regulations could be the best candidates. They could be most effective. But if you look at this diagram, I'm not saying that we should just focus on these two. Maybe we could take some parts from the architectural regulation, and we need to put some restrictions on architectural regulations, and we could take some aspects from the hard law regulations. And so this could be a hybrid. So depending on the situation, we should be able to pick and choose from the different regulatory models, but basically it would be best to combine the two colored models, the soft law and the architectural regulations. In order to have a hard law regulatory model, we need to have some legal grounds, and it's difficult to establish those at the moment, so that's why I chose these two as potential candidates. So what is the reality of the AI legal regulation at this point? We're in the stage of formulating the legal regulations for AI. But in forming the regulations, Korea is not alone. European countries are also coming up with laws and acts, but they're just tentative. And they're doing impact assessment. And in the EU countries, they're also in the process of constituting legal regulations for AI. So how should we understand this situation? Traditionally, we could take hints from the information sociology. There's the notion of technology determinism. It is of the position that social factors change with the technological progress. Technological progress drives social growth, and another notion, social constructivism, is of the position that technological progress is driven by social necessity. Many of the humanities scholars are of the social constructivism, but now the trend is co-evolution of technology and society, or CTS. So this is the view that technology can drive social change and needs, but also vice versa. So if the CTS is the case, what is the normative implication of the co-evolution? Technology affects the norms, and norms also, in reverse, affects the technology. So in this paradigm, we need to approach the regulations for AI. In selecting the factors for the AI regulation, we need to know about what factors there are. I'll be very brief with the explanation. There's the type of code of ethics establishment. We do talk about AI guidelines and ethics. So instead of coming up with the laws first, it would be a first step to establish the guidelines for ethics. And second is to build a certification system. We have similar measures in the EU and Japan. I talk about certification here, and you could call it auditing, and you could use similar words. You need to establish some sort of a certification system for safe use of AI. So it's a monitoring system, not so much a legal framework. And the third type is establishing rights and obligations, as is in the GDPR. You may request explanation. And there's the EU regulation on online platform. Rights and or obligations are established in these regulations. When rights are imposed, the other party may be given obligations. So this is some sort of regulation in that sense. And lastly, we have the mandatory measures in the EU. They talk about obligations of providers of high-risk AI systems. So I talked about the four types of regulations. It goes from weak regulations to strong regulations. So in order to accommodate the co-evolution of technology and science, which type should we choose first? I'm not saying that we should go with the ethical guidelines first. We're all in the process of establishing norms. So I'm just saying that we should go from weak to strong. And in terms of AI technology regulation, there are many possibilities, but as I said before, laws targeting AI technology is not clearly laid out in Korea, in the EU, and in Japan. They're all in the formation process, but when we are talking about regulations, we do have the Act on Promotion of Information and Communications Network Utilization, Information Protection Act, etc. So there is no single act, but it does discuss AI indirectly. But in Korea, we do have some laws related to AI directly. Intelligent Robotics Development and Dissemination Promotion Act. It was a temporary law, but interest in AI increased, and the law is still in effect. And recently, we had the Basic Act on Intelligent Informatization. It was for agenda setting. It started as Informatization Promotion Framework Act, and it was fully revised to National Informatization Framework Act, and then Basic Act on Intelligent Informatization. And it does touch upon AI. And so now I'd like to talk about the AI human rights impact assessment and whether it is necessary. I would like to cautiously state that the impact assessment is important in formulating the relevant laws and regulations. The Ministry of Science and Technology had produced the ethics guideline for AI, and National Human Rights Commission had also produced guidelines, and the Ministry of Education also. So in 2022, the Ministry of Education had produced the ethical principles for AI in the education sector. I think the relevant ministries will be producing their own guidelines for their relevant industries. And we also have the human rights guidelines for the use and development of AI produced by the National Commission of Human Rights. And this does mention the AI human rights impact assessment. In order to deal with the risks and also to contribute to norm setting, we need the impact assessment. And in the interest of time, I'll be brief with the rest of the presentation. In order to make the judgment, we need to take into consideration many factors. But it's difficult to consider everything, so we need to apply the rule of proportionality. And we could have the impact assessment for proportionality's sake. And there are two things. To talk about AI, we could have the impact assessment for the social aspect, the legislation and policies could be the target for impact assessment, or we could have the impact assessment on the technology itself. I looked at the trends in other countries, and it was more common that both social and technical aspects were considered together. In Korea, they're separate. I'm not saying that we should not separate them, but I do agree that these two aspects should be considered. Then why do we need impact assessment? Because new human rights will emerge and new concepts of human rights issues will emerge, and that will be because of two reasons. There will be less or no human intervention, and autonomous decision will be made through AI technology. That is one stream of context. And the other is the decision-making process is done by the machine and it is not revealed externally. So there's this issue of transparency. And so that is why human rights issues will become more pronounced. So it's just because humans cannot control it, we won't just let it be. We need to systematically establish some sort of monitoring system to check possible dangers and risks. And this is a sample impact assessment system. I talked about the two different types, social aspect and technical aspect. We have the technology impact assessment under the framework on science and technology. That's looking at the technological impact. And for social impact assessment, it is under the Framework Act on Intelligent Informatization. So it looks at the technology or the services. And when we talk about impact assessment, we talk a lot about the personal information. So this is about privacy impact assessment under the Personal Information Protection Act. It is comprehensive, and at the same time, the impact assessment is concentrated in one particular sphere. So this is to perform impact assessment related to human rights. But privacy impact assessment is targeting privacy. So I don't think we could directly apply this to AI, but I'm just showing you some examples. They have their own limitations. But The conclusion is I do think we need to have AI human rights impact assessment, but it's difficult to directly perform AI human rights impact assessment. So we could borrow some ideas from the other models. There could be a couple of types: institutionalized legislation and policy impact assessment. I did quote an EU document. As for the EU, in the past, they did SME and environmental impact assessment, technology impact assessment. They integrated it into one single impact assessment. And this is complete as of 2002. Technology impact assessment is done under the EU Commission's impact assessment. And what is desirable is if we want to have the human rights impact assessment, I think it would be very good to systematically do it. But since we do not have that single impact assessment system yet, maybe we could build it separately or support it so that it can be adopted in society. So I came up with two candidates. The impact assessment is to deal with potential risks, but in the long term, it's just one stepping stone closer to formulating the regulations. So with this, I'd like to end my presentation. Thank you.
네, 심우인 교수님 감사드립니다.
Thank you, Professor Shim, for your very interesting presentation. I'm sorry that there is a limit to the time. I have personally deep interest in the topic and I learned a lot. Now we will invite the second speaker, who is Dr. Choi Ji-sun, the Associate Research Fellow of KICJ. The floor is yours. Good morning. I am Choi Ji-sun from KICJ. Today, I would like to talk about the application of AI decision-making in criminal justice system. I will cover ethical implications and reliability. Dr. Song Yuri, who is sitting next to me, and myself, we majored in social science, so we are sensitive to data-related issues because we do our research leveraging data. So as we access these data, research ethics are sometimes an obstacle that we face, especially when it comes to data subjects or research subjects. If they are criminals or victims, ethics in research becomes a more critical issue. So I will cover research ethics based on AI technology in the criminal justice field, and Dr. Song will go into further detail in the following presentation. Well, the main question is as follows. After the introduction of the concept of AI, there were much talk about whether AI could substitute a human being. When it comes to criminal policy, this issue has been heavily discussed, especially big data, AI, machine learning, and decision making are some terms that are used together, and sometimes it is difficult to distinguish these terminology. Big data is the material itself, and AI is the tool that is used for decision making. So the most essential part is the data that is used. Well, machine learning, AI are more technical issues. So I think it is beyond the scope of our discussion. Well, we should focus our discussion on how we could leverage the big data that is accumulated in the criminal data. When it comes to AI decision making, it is often used in the field of business operations, managing a company or problem solving, strategic changes, customer related decisions, and performance assessment are some aspects that use AI-based decision making. If you look at the top left chart, it shows the decision making model based on human judgment. So a person would use factors such as emotions to arrive at a business decision, and to the right, it shows the process of evidence-based decision making, which utilizes data to a certain extent. If you look at the left bottom chart, it shows how big data is used by the AI to reach a business decision. So this is where AI is fully in charge of decision making. And the bottom right chart shows a process where AI-powered data analysis serves to support human judgment. In the criminal justice field, there are various processes of decision making for various purposes, from policing to sentencing, correction, community supervision, up to crime prevention. We see decision making taking place in various fields. Let me give you an example. Let's say there is a report filed to the police. They should decide whether to be dispatched to the field and whether to arrest the criminal and whether to prosecute the criminal. And even if after the criminal goes to jail, there is the option of deciding whether the criminal can be released earlier. And when it comes to community supervision, if there are obligations that have been breached, decision on the penalty or punishment should be made. And whether to extend or shorten the disposition, a decision also has to be made. Also, for crime prevention, there are many decisions that must be made with regards to which area to patrol and what policies to apply. So these are only a few of the very many decisions that are made in the criminal justice field. In fact, there are all sorts of decisions being made in this field, and if AI is to be leveraged, we would have to decide where and how to apply AI. In the past, decision making was largely based on instinct. So based on the capacity of a specific individual, the thoughts, the thinking process, and prediction of a person would be largely reflected, and guesses and biases or perceptions of a person would greatly influence the decision made. But we saw a transition to give a heavier focus on crime statistics and data, which was proven to be helpful to prevent and reduce crime. Well, in my personal opinion, I think we have seen more use of scientific data in this transitional phase. And as we head to the future, I think we are still in this phase. We are seeing a shift to use big data and AI deep learning for decision making. That is what we are currently headed to. So, AI supported decision making can be explained through two main examples. The first is the AI crime signal prediction system. It is currently used for electronic monitoring. It is a widely known disposition, which is especially applied to sex offenders. Under the judgment that there is high recidivism rate of sex offenders, electronic monitoring system is applied. And AI-based prediction system went through a pre-test in 2018 and was launched in 2019. Recently, the system was upgraded to use big data more actively. And the data that is used by the system includes the data subject's basic information, including their socioeconomic status, the crime, and the sentence of these criminals, and also the reports on these subjects filed by probation officers. And the system's major functions include providing the subject's daily risk level to the probation officers and also provides a real-time risk assessment of the subjects. And the probation officers file or draft daily reports on the subjects, and for low-risk subjects, the daily report work burden is reduced for these probation officers. Using AI to leverage the data on these subjects, there is a prediction made on the risk level for recidivism for these subjects. In this case, it is hard to say that AI is making the decision themselves. AI produces the data that is provided to the probation officers who are in charge of making the decisions. So when we talk to those who are in the field, we hear that the analysis outcome produced by the AI system is a bit questionable in terms of reliability. Sometimes the probation officers would deem the risk level to be low for a certain criminal, but the AI outcome would show a high risk level for that individual, or vice versa. So probation officers think that the AI system's reliability is not very high. So the current state is that AI is not really being made for used for decision making. This is a chart that shows how the system works based on information on the data subjects. If there is an irregular activity that is recognized, it gives an alert to the probation officers and enables them to swiftly respond to the situation. Another system is the precast system. It is used by the National Police Agency, the Korean National Police Agency, and the National Information Resource Service collaborated to develop this program, which is now in use. data that is used includes public safety data and general public data. So the functions that it serves is to predict the risk of crime occurrence by region and to decide the patrol routes. Those are some purposes the system serves. Also, the police uses the system to identify which areas are more crime prone and which areas are in need of more surveillance cameras. Those are some aspects that the program can be used for. This program uses the data to produce outcome, but in the end, the ultimate decision maker is still human beings, and they are the ones who act on the decision. Moving on to ethical issues of AI in crime prediction, the critical issue is data. Currently, criminals and public's data is used in these systems, so there's the issue of privacy infringement. Also, we know that surveillance cameras are in operation, but some people may not be aware it is used for crime prevention. The use of such footages is not based on consent of everyone who might be recorded in it. So there's the problem of the scope of people who needs to provide consent. And when it comes to the issue of personal data, in Korea, we tend to prioritize public safety. So there isn't a very strong resistance to the use of such personal data. But even if we do use such data, there is still the question of reliability and accuracy of such data. I would like to briefly mention the goals of the criminal justice system. There are many, including public safety, rehabilitation of criminals, and providing necessary services to the victims. When it comes to these goals, what we have observed in terms of data use is that we have heightened awareness about the rights of criminals. So in that aspect, much discourse is taking place, but the rights of the general public should be considered more, especially to prioritize the public safety. That is an area where I've observed some gap in. The most critical question is what is more important between individuals' rights of the criminals or the public safety. So to what extent can we use data of criminals to achieve public safety? Currently, still there is the issue of whether such data can be used without consent of the data subjects. One of my personal concerns is that while there's much talk about ethical issues related to AI, well, in fact, there has been much talk on whether AI can replace human beings, and that topic has been heavily dealt with, but there's not insufficient discussion on the reliability and accuracy of the AI systems. Professor Shim mentioned that currently there are efforts being made to that end, but I think AI should, of course, be certified or validated, and that discussion should take place in parallel with talking about the ethical issues of AI systems. So I would like to touch upon the issue of reliability and accuracy of AI systems. If that issue is resolved or addressed, I think it would help us gain or acquire consent of those who are affected. And there needs to be more evidence provided that could testify to high reliability and accuracy of the AI systems. And we should provide that evidence when we ask for consent of the public or the criminals. I think we are a bit hasty when we jump right into the discussion of ethical issues, of whether it infringes on the privacy. First, we need scientific validation on the reliability and accuracy of these systems. So that brings us back to the main question I mentioned in the beginning of my presentation. Well, I think in the criminal justice system, AI will not be able to replace human beings. Discretion is a key word in this field. Discretion is actively employed to make decisions in the criminal justice system. If such discretion-based decisions are to be substituted by automated AI decisions, there are many aspects that would have to be validated in advance. And the social scientists in our institute and other researchers in this field should first take a look at whether AI systems are reliable and accurate, and to facilitate such research, more data should be provided. Lack of data poses much limitations to research activities in that aspect. Well, in the near future, how might AI be applied in the field? I have been constantly emphasizing the necessity of evaluating reliability and accuracy of the systems, which should take place in parallel with the discussions on ethical issues. And as you've seen, crime prediction systems, the two systems that I have shown, are only a few examples out of more systems that are currently being developed. The system developed by the MOJ and that developed by KNP AI currently separated. But for big data to be more effective, the scope should be larger. So I think the systems of the different agencies should be integrated for the data to be used and leveraged more effectively. And the ethical issues should be addressed so that we can make more use of the information and data currently available. So I would hope to see barriers be overcome. AI will replace many aspects of our lives, but I don't think that is very feasible in the field of criminal justice system. However, I believe that AI could provide much support for those in the field. So brings us to the close of my presentation. Thank you.
좋은 발표.
Thank you very much. We have limited time and we could not give you more time. As a moderator, I am very interested in this topic. I'd like to talk about three things.
현재 우리 행정
Well, based on our basic administrative law, the fully automated decision can be applied to only a limited number of aspects, and when suits are filed, if personal data is used that might be a breach of personal data protection law, it could be for a justifiable cause, but still there is a very strong protection of personal data in the recent case law, and sharing information is very important. And we need more development in the scientific technological devices used for right sentencing. So now I would like to invite our last presenter, Song Yuri, who is an Associate Research Fellow of KICJ.
Hello, I am Song Yuri with the KICJ. I'd like to talk about applicability of AI in government agencies and how human rights is being hampered. And I'd like to give you a specific case example. I'm going to talk about the behavioral analysis conducted in the Scientific Investigation Department of the Supreme Prosecutor's Office. It's part of the lie detection system. It's to evaluate the validity of the statements given. Many people think that it's very difficult to find out what the suspect is saying is true or false, and you could validate the truthfulness of the statement by looking at their physiological changes like brain waves or heartbeat. If the heart rate becomes faster or you have more blood pressure, higher blood pressure, or you take quicker breaths, then this is shown. And using the polygraph, when somebody is telling a lie, a certain brain wave is observed on the plot. So you will know that the person is lying. And as you've seen on the TV, you could wear the headband with the cat's ear, and this is also using the brain wave. Sometimes when the person lies, the ear twitches, and when you also have the lie detector of where you place your palm on a certain device, when you lie, you have higher blood pressure or your palm sweats, and then the device is able to pick up those lies. Behavior analysis analyzes certain behaviors. The sphere of behavior analysis is quite wide and comprehensive and is used in many areas, but Supreme Prosecutor's Office uses the emotional changes and the body movements and facial expressions to find out the validity of the statements given. So easily put, if a person lies, there are some nonverbal characteristics like the leg shake or the shoulder shake, or you constantly change your posture, and when you tell the truth, your eyeballs look to the right, but when you lie, your eyeballs look to the left. So this is part of a wider behavioral analysis, and the behavioral analysis adopted in the Supreme Prosecutor's Office is to find out the validity of statements given by the suspects, victims, or witnesses of violent crimes. So we mainly use this on suspects of violent crimes where the evidence is not fully given. For the case of serial killer Lee Chung-jae, behavioral analysis was done, and other serious and violent crime offenders have gone through the behavior analysis. And you can see how actively the Supreme Prosecutor's Office is employing behavior analysis. Then how is this analysis done? A special interview technique is used, and during the interview, everything is recorded, and the videotaped interviews are observed from end to end and picks up on any indicators that reveal a possible deception. So these are the 4 steps of behavioral analysis. Once the first step is you look at the changes in behavior, facial expressions, or emotions, and then with the indicators, you try to recognize the information. Is it joy, happiness, anger? And if there are changes in the behavior, what does this mean? And after the second step, with the information collected, the inference is made to what psychological state that person is in. And then the 4th stage is to determine the credibility of the statement. So these are the 4 steps of behavioral analysis. And what is first used is the indicators, behavior indicators. Look at the changes and the facial expressions, emotions, body posture. Did you see the US drama Like Me? It shows the actual indicators of behavioral analysis. Shake in the shoulders, or shifting in the posture, or shaking in the leg, or any strange habits shown in unusual dialogue setting. The analysts try to pick up these changes, and then they check the changes frame by frame. And it's not 1 second, it's like split second, nanosecond unit. They check the changes in the behaviors in such a split second. So the interview lasts about an hour, but the analysts will take up to 2 days to analyze the whole data. So they're quite under fatigue, and the work efficiency is very low. And the accuracy of such credibility evaluation is very high. And so it's very regrettable that they can only do this behavior analysis on few people. I think it could be applied to more people when there's scarce direct evidence. It could be used as circumstantial evidence in court. So evaluating the statement's credibility could be supported with some technological assistance. And the Supreme Prosecutor's Office is looking into the possible applicability of AI, and they have commissioned a project, and I was on the project, and I am sharing with you part of the results in a preliminary format. I'd like to give you a specific example. We have microexpression as one of the indicators.
진짜 감정.
Microexpression reveals the true emotion of a person, no matter how hard the person tries to conceal their true emotions. In a matter of 0.25 seconds, the real emotion is revealed through a split second of microexpression. For example, if a criminal is pretending to be a victim and is confident that he or she managed to fool the inspector, the sense of pride briefly is revealed on the face. An untrained investigator cannot notice such micro expression, and it's very difficult even for a trained investigator to notice it. That is why they must recheck recorded footage of the investigations or inspections. We can see that AI technology is urgently needed. We have studied more than 100 of papers on whether there is a technique used to detect microexpression. Well, those highly accurate algorithms have an accuracy rate of about 80 to 90% in detecting microexpressions. But why is such technology not leveraged in the prosecutor's office? There are two issues. First, the intensity of such microexpressions is very weak. It briefly is shown on the face in a matter of a split second. So it is hard to detect the expression or the changes in the expression. So this is a technical issue. And the second issue is the lack of number and variety of microexpression data. The current AI technology uses a specific data set. That data set is synthesized in a lab. For example, if a person tries to suppress sadness when watching a sad movie, those micro expressions are made to test how well AI can detect such expressions. Most papers are based on such studies, so there are only 4 to 5 data sets of such micro expression data, which lacks variety. So, can such an inadequate technology be applied right away at the Supreme Prosecutor's office? It's doubtful. Well, a criminal of a violent crime such as rape or murder might show a range of micro expressions that are qualitatively different from those produced by other ordinary people. Then, AI technology to detect microexpression, however, has an opportunity to be used by the prosecutor's office only if one issue is addressed. Though the interviews of real inspections in the footages of real interviews in Supreme Prosecutor's office should be used to study the microexpressions and to label the baseline and train the AI through deep learning based on such footages that would greatly boost accuracy so that it can be employed right away in real cases. However, developing technology using behavioral analysis images is deemed to be very difficult due to issues related to use of the data. Dr. Choi mentioned this issue. There is limited use of data, so it is hampering the use of facial expression and behavioral analysis technology. According to Data Protection Law, Article 15, such data can be used if there was consent. The consent form indicates that the purpose of data collection is for fair inspection and human rights protection. If it is a vague purpose for use of data use, I think that might be why there is lack of usage of such data in public agencies. But I think this behavioral analysis is included in the scope of collection and use of for fair inspection and human rights protection because a more accurate analysis could serve to protect rights. Also, fair inspection is part of the human rights that a criminal deserves. Second, attempts to use AI in such a professional field of behavioral analysis, AI is not leveraged to the extent that infringes on human rights. If we are to employ AI all the way up to the fourth or the highest level that might infringe on personal data. There are issues due to indeterminacy of AI, so that might infringe upon the right for a fair judgment. But behavior analysis is done by experts. So, an expert, a human agent, must conduct evaluation and assessment. AI is merely a tool that serves that purpose. Therefore, AI will be leveraged only to an extent that does not infringe on human rights, and it is questionable whether such use still creates human rights issues. In such fields such as behavioral analysis, I think we should refrain from hampering technological development under the cause of human rights protection. We should impose regulations based on the purpose and scope of the use of such technology that would serve to minimize any human rights infringement by AI technology and pursue co-development of the technology and society. Thank you.
네, 세 번째 발표 잘 들었습니다.
Thank you, Dr. Sang. This is interesting. I'm not really knowledgeable on this field, but I think you gave us an interesting example. We are quite behind our schedule. We'll go right into discussion. As the first discussant, we have Ms. Chang Yeogyung, who's the Executive Director of Institute for Digital Rights. I would like to ask you to spend about 20 minutes. Okay, I'll be very quick. I would like to talk about this issue from a human rights perspective. I would like to just make brief comments inside quoting some Korean examples. The presentations made, I think they're in the formulation stage, so they're intriguing. But at the same time, I noted the expressions of how human rights is in the getting way of technological development, and that gave me concern. And can we judge who is a criminal and who is not? And looking at the international human rights norms says that in developing AI, human rights standards must be complied. So I'd like to share that, citing some examples. The biggest risk of AI is safety, discrimination, and privacy violation. And we also have others. The right to a fair trial could be jeopardized with the use of AI. And so, how should we come up with the legal requirements, and what are some of the remedial measures? And so, the regulatory bodies should be quite clear on their enforcement rules. And as was mentioned by the moderator, the Administrative Basic Act is enforced, and there could be automated public dispositions made. And one example is traffic enforcement. Automatically, the speed is detected and the car plate is recognized, and the ticket is all automated, and we see such cases in overseas. But there could be some errors in the car plate recognition, or my car cannot drive up to that speed. How can I file a complaint? What is the due process, and what are some of the compensations made? So we need to have the legal requirements. And also 2 days ago, the revision of the Personal Information Protection Act was tabled, and if this is passed, explanation or raising objection could be possible in the later stage, but we need to solve a few more issues. And for the remedies or due process rights, if they're not explicitly stipulated, the dispositions, the public disposition was passed. And another contentious issue was the facial recognition technology used in immigration service. This was a case in point from 2005 to 2011. All the nationals and non-nationals who passed through the immigration in Korea during a certain period had not given their consent about the use of their facial and biometric data. The initial ruling was this is not illegal, but now it is in the constitutional court. And they're saying that the Ministry of Justice is saying that it complies with the objective of identification of the person in the immigration service. And so this facial recognition technology could be used at the immigration. But the basic fundamental rights are not jeopardized. And as for the remedial measures, in order to make remedies possible, the person will have to be aware of how my data was used. Some people, nationals and non-nationals, have made a request, but it was very difficult to find out how the training data was used, and recently the data was purged, and so you cannot view the data, you cannot know how your data was used. So we need to have some remedial measures in place. And this is not controversial. Only in Korea we have similar cases overseas. AI and limiting basic fundamental rights. As for facial recognition and enforcing regulations, there are some human rights agencies that have come up with their statements. In using the facial recognition technology, you could use the technology, but there were some limitations or prerequisites to be met. An independent body must be in charge of oversight, and when there's restriction of fundamental rights, it has to be written in law, and it has to serve public good. But is it really for serving the public good? And you have to respect the essence of the fundamental rights. You cannot serve the public good in an abstract sense. You have to always find out, is there any alternative to serve the public good and in a non-invasive way? And you have to think of the principle of proportionality. And you need to infringe upon the basic human rights to the minimum. So legislative acts are now being developed, and one is the proposed regulation on AI. It was announced last year, and it is under review. It talks about the high-risk AI, and there are complex regulations and measures to curb high-risk AI. They first define what unacceptable AI is. If it is a clear threat to safety and livelihoods, or real-time remote biometric identification in the public places, that is banned. And they could file for exceptions in courts. And as for the high-risk AI, there are two parts. One is safety components or products like elevators, cars, and medical devices. And the other, Annex 3, are the AI that could have limitations on the human rights exercise, law enforcement systems, or administration of justice democratic processes. You need to do risk assessment before marketing, and there has to be data management. There has to be documentation and logging. And before launch, there needs to be conformity assessment, third-party assessment for the Annex 2 type of AI, and self-assessment for the Annex 3. And you need to have CE certification mark, and there needs to be constant quality management and monitoring, and in cases of violation, high penalties to be paid. And criminal justice field, there are a lot of debates and controversies. Mostly, it's about real-time remote biometric identification in public places and predictive policing. Last year, the European Parliament came up with a resolution. It cannot perform the biometric identification, and predictive policing is to be banned. And the UN High Office had released a report saying that the emotion recognition technology is prone to error, and you have to take into consideration different cultural aspects. And just looking at the facial expressions and the emotions, there's not a direct correlation, so it could lead to potential human rights infringement. So in the actual law, they're thinking of whether to categorize this as unacceptable or high risk.
개인정보 보호
Also, there were much talks about personal information protection, and for it to be legally guaranteed, there are requirements, including the consent requirement. But when it comes to the state and citizen, such consent cannot serve as an legal grounds. According to the GDPR of the EU, there aren't any case law in Korea, but I think it is legitimate, the case we saw in EU, because the principle of statute reservation should be applied to cases where process of personal information limits basic right. Criminal data often includes sensitive data, and according to an enforcement decree of Korea's Protection Information Protection Act, some sensitive data are stipulated as exceptions when it comes to public authorities' efforts to make indictment or maintain indictment, including genetic data. And when it comes to the profiling that integrates much data, there is a lack of concept and regulations. There are increasing cases where different personal information are converged and integrated, and a lack of regulation in that field is an issue. And there was the issue of automated decision making, but I think such issue can largely be addressed through legislation. But there is still a lack of rules that can be applied for notification. And currently, there is less limitation to automated decision making compared to EU's GDPR. This was pointed out by the National Human Rights Commission. And human rights impact assessment is the topic of much debate since last year, because independent evaluation of human rights management is being introduced by the public agencies. And by 2030, all KOSPI-listed companies will have to undergo such human rights management evaluation, and many are voicing the need for human rights due diligence and human rights impact assessment when it comes to new emerging technologies. there was a resolution by the UN Human Rights Council that says states should make it mandatory for companies to undergo the human rights assessment. There's much effort to that end. There was the human rights guideline released in Korea, and guidelines for human rights management have been recommended and published. And there is much research service for human rights assessment. Also, for AI used for procurement, there are guidelines that makes it mandatory to undergo AI impact assessment. And the algorithm impact assessment and human rights impact assessment are related in a mutually complementary nature. If we look at the impact assessment of the algorithm of the NHS of the UK, we can see the case here. But although such algorithm impact assessment and human rights impact assessment could be complementary, one cannot replace another. And currently, these are taking the form of a soft law. There was a basic proposal for the human rights policy, which led to much debate. It said that the state could publish or release the criteria for human rights protection, but it was deleted. Well, there is the opinion that the state should provide a unilateral and uniform criteria for protection of human rights. And last but not least, we need a hybrid approach when managing this issue. The UK's Digital Regulation Cooperation Forum provided the different types of audits. There are different types of algorithm audits. There are 3 types. First is the governance audit, second is the empirical audit, and third is the technical audit. So, as a precaution measure, we could first take the governance audit approach, and in order to determine whether an act was a breach, we could take the empirical audit where we look at the effect of the algorithm in light of the input and output. It is often used by the Fair Trade Commission. And for a more precise audit, we could take the technical audit approach. So a hybrid approach is being discussed. So I think this could serve as a tool to address the issues. But when it comes to the criminal justice system, there is large risk of infringing upon the basic rights of citizens. So I think soft law is inadequate. Well, I think more precise provisions rather than a general provision should be established. That would be the end of my discussion. Thank you.
Thank you for your valuable comments. You raised very important issues. And now I would like to ask Dr. Kang Tae-kyung from KICJ to make his comments. 15 minutes, please. Yes, I am here. Thank you for the 3 presenters, and it's an honor to be one of the discussants in this session. I will read my discussion paper. The three presentations showed the trilemma that we are faced with in terms of using the AI technology. We are dealing with the tension between the factual aspect of the AI technology and the normative aspect of how we cannot violate the human rights. We need to allow for the technological advancement, and also we need to protect the human rights. So that is the trilemma situation. And I'd like to talk about how we can overcome this trilemma using algorithm bias in predictive policing. As for the international norms, I think Ms. Chang Yeogyung talked about it. So I think it would be better to talk about this algorithm bias. We see a lot of criminal data analysis and machine learning program is used in predictive policing. And this has the issue of algorithmic bias and discrimination. The algorithm bias comes from the social pattern reflected from the training set of data. And COMPAS is a good example. COMPAS, in predicting the recidivism, it has an unfavorable bias toward the blacks because the two groups of blacks and whites in the training data set start with a different arrest rate. According to Johnson and Danks, when the algorithm itself is neutral, the algorithmic bias comes from the training set, and it's an implicit bias. And if you change the algorithm so that you cannot willfully use the sensitive information like race, the bias does not go away. Even if the algorithm cannot use the racial information, it would use the proxy attributes like the address information or race and make its predictions. So instead of the algorithmic approach, it would be better to change the social pattern reflected in the data set to reduce the algorithmic bias? And is it effective to regulate the algorithmic bias in a legal measure? When there is discrimination due to automated decision making based on the AI algorithm, this is because of the past data, and the discrimination is subtle. So banning collection of information because of discrimination, or having the post-remedial measure for compensation for discrimination, it's difficult to regulate the algorithmic bias. Of course, we need to regulate in other aspects. And public investigation or oversight in algorithmic design could not be as effective. But if we have prior regulation for the algorithm, it could also infringe upon privacy or the company's trade rights, trade secrets. And what is the way to reduce some of the algorithmic bias in crime prediction? I think if XAI was introduced, it would be better, but it's not the case yet. And what we need to look out for is the algorithmic bias in crime prediction gives rise to human rights infringement and discrimination, and this is due to the interpretation bias of humans. The crime prediction algorithm makes its judgment based on past crime data, so this reflects the past data's intrinsic structure. But if the police uses this algorithm and makes the direct connection between the crime risk and the neighborhood and the group, then this is a bias in its interpretation, and it's normatively biased. Let's say there are Y type of people living in the X neighborhood. Y people have lower socioeconomic status, and X neighborhood has fewer CCTV cameras. And if the algorithm produces the results that the X neighborhood is prone to crimes, then for the police not to give rise to discrimination, they should look at the proxy attributes like the CCTV cameras and the socioeconomic status. And if you just increase the numbers of patrols in the X neighborhood, then you're liable to catch more crimes. and then you are likely to categorize neighborhood X as a crime-prone area. But if you install more CCTV cameras and if you have more after-school activities for the youth so that the youth are not left alone at home, then in the long term, X will not be discriminated as a crime-prone area and you could have less crimes.
통해서 범죄
Through such a hypothetical example, we can see that the crime prediction algorithm should be limited for only an epidemiological survey, not a diagnosis. Diagnosis is getting grounds for therapeutical method by identifying the health status of an individual, while an epidemiological survey is using statistical data to identify the status of a group. So looking at the crime risk for an individual is a diagnostic prediction, while looking at the risk at a group level is an epidemiological prediction. But the diagnostic prediction could lead to many problems. Even if we look at the statistical technique used by techniques, it would be justifiable and right to limit the use of algorithms for an epidemiological prediction. Usually, the big data includes many variables, and the prediction algorithm uses machine learning to learn that big data, which includes general tendency or the abstract risk prediction data, and it calculates the correlationship between the various variables. But using such algorithm for a specific risk, it could lead to alternative context bias. Therefore, the crime risk is predicted through various variables, and the social patterns related to such variables should be changed through investing resources. For example, we could make tweaks to the data that the algorithm is trained with, such as the rate of surveillance camera installation. And by comparing the outcomes of the algorithm that is trained with different data sets could give us hints on how to fix such normative biases in the data sets. This could lead to the most optimal tool or way to reduce the risk of crime risk. Use of algorithms is in fact effective for reducing crime rates, but when it is used to predict the crime risk level of individuals, there is lower effectiveness and accuracy. Such errors of crime prediction level for individuals could lead to discrimination against a certain group of people. So regulating the algorithm bias itself is not feasible due to lack of transparency and the inherent flexibility of the algorithm. However, we have seen attempts to compare the different models with the different data sets to address the biases. If there is not a huge difference between the outcome, what should we do? We should take decisions that could guarantee the maximum level of freedom. Well, rather than the accuracy of the algorithm itself, we should look at the potential error rate that could wrongfully predict a certain region with low crime rate as a crime-prone region. We need to focus on lowering the false positive errors. This would comply with the in dubio pro libertate principle in the normative perspective. Thank you.
제한된 시간에 효과적으로 좋은 토론 해주셨고요.
Thank you very much. We were able to gain new insight from your discussion from the legal philosophy. We should avoid legal or reasoning, inferential reasoning based on errors. We were supposed to end this session at 10:15, and I have to join another call at 11. We have 5 minutes left. Are there any last-minute comments from the three presenters? We have 5 minutes. Well, as for me, I did talk about regulation, and what came to my mind listening to the comments was, as was mentioned by Ms. Chang Yeogyang, because of the use of data, we could have some criminal justice review processes that are jeopardized. And I don't think that was what you were intending, but that gave me some concern. But as was mentioned by Dr. Choi and Dr. Sung, overall, you talked about the social science-based analysis. When we talk about impact assessment, it doesn't have to be human rights, but in the process of impact assessment, the social science analysis factor is included. And when we talk about the criminal justice system, what gives me concern is when there is data integration, I think good values will be created, and I think we tend to focus on data learning. But when we talk about integration, the government will have a large data set, and that could lead to some potential risk. And when we talk about AI algorithm, we do talk about bias. That is important. But if we focus on the AI itself, I think we need to think about the algorithm's own attributes. So when we do a human rights impact assessment, I think we need to look into the attributes of the algorithm itself. With that, I'd like to end. Thank you.
다른 두 분 또
Now, could we hear from the other two presenters also? Well, as Director Zhang mentioned, the data-related issues could hamper technological advancement. Maybe I was a bit nervous and I gave off the wrong nuance. That was my intention. When it comes to technology itself and its use in the criminal justice field, use of data is critical. That is the message I wanted to convey. And I really agreed with Dr. Kong. Well, instead of using AI to make decisions about individual persons, I think it could serve the purpose better when it's put to use for analysis of larger trends and groups. Thank you. Last but not least, Dr. Song.
Thank you for your valuable comments. It gave me a chance to think more about human rights, but nonetheless, as I alluded to earlier, in the expert field, it's not that we are going to adopt a fully automated system. And in the areas other than that, I think it would be desirable to adopt an AI system that is fit for purpose. And I think, we should not be blindly against it and think about all the options, because what I'm trying to say is, instead of decision-making support tool, detection and discovery are the roles and functions that could be supported by the AI. And I think I don't think we should apply a rigid set of regulations to that type of AI, because we need to think about how we can promote the development of AI. I will go back and do more research, and I hope there will be a future chance to talk about this further. Thank you.
자, 오늘
Thank you for your last comments. Now the time is up for session 2. I it's unfortunate that we don't have enough time to discuss the many outstanding issues, but I hope there will be another occasion to address those. I would like to thank the 3 presenters and 2 discussants for joining us today, and that would be the end for me. Thank you. Thank you, moderator and Professor Yang Chun-soo. And the 3 presenters and 2 discussants contributed so much. Thank you. So that brings us to the close of the 9th International Forum of KICJ. We looked at the theme of emerging technologies and human rights from a legal and ethical consideration perspective. Human rights-based AI use should be promoted, and I hope more discussion will take place with regards to that topic. So that is the end of our forum. Thank you.